what I wanted to say about the law so that you know if any of this kind of discrimination is occurring in the workplace, in public accommodation, or in housing, if you're being harassed, or decisions are being made about your employment based on this new protected category. For employment, you have 300 days from the last date of harm to file with my office. The law, there's been some case law that's interpreted the way the law is written that says that you have to go through an administrative process first before going to court for employment. The law has been interpreted. So what that means is you have to file with my agency to allow for the administrative purpose, and then you can go to court. So you don't want to go straight to court because you could get booted out for not having gone the proper route. And that timeliness issue is also in the law. So if it's 301 days or anything longer, it's not jurisdictional. We couldn't take it. So know that you have that limitation for employment. It's 300 days for public accommodation as well. You go into a restaurant, they refuse to serve you, or they don't let you use the bathroom of your choice. You have 300 days to file a complaint with my office. That is protected, and we would investigate that. Housing, you have 1 year. And by housing discrimination, we're talking about either renting, leasing, or buying a dwelling. And the stipulation is there have to be 3 or more units, or an owner has to own 3 or more houses, apartments, or duplex units. So if it's a single person that owns a second house that rents it out, that protection is not there in the law. It has to be a minimum of 3. But if you think you're not being allowed to rent a place or buy a place or even be shown a place that you're interested in because of your gender identity or expression, you're protected under the law from that. You are also protected in housing from a form of harassment, from the terms and conditions of you dwelling in that place. So if you're being harassed for your gender identity or expression or any of the other areas that are protected under the law in your housing, in the terms of your lease. Well, let's say the property manager says, you know, you've got to come in the back door because we don't want folks to see you. That's absolutely something that could be filed at my office. So it's mostly, you know, renting or purchasing and associated circumstances, but it also includes harassment and the terms and conditions of your lease or your agreement. In public accommodation, it's equal access, equal enjoyment of that place of public accommodation. And it's a place open to the public. So a lot of the places you might think of, you know, restaurant and bars, gyms, schools, as far as public areas of the schools, that gets a little tricky. But any place that's open to the public, if you're treated disparately or not allowed equal enjoyment, you could file a complaint with my office. The last area I want to talk about specifically has to do with grooming and dress code standards, because that's come up. It was another kind of point of contention, and they actually wrote something into the law, the state law, addressing that. This is in the employment section, and it says, it is not an unlawful employment practice for an employer to require employees to adhere to reasonable workplace appearance, grooming, and dress standards, so long as such requirements are not precluded by law, except that an employer shall allow an employee to appear, groom, and dress consistent with the employee's gender identity or expression. So to me, 2 really important things in there. One is they can ask you to adhere to a reasonable, that's to me a key word, reasonable workplace appearance, grooming, and dress code standard. And the other part that's important is it says that you should apply the dress code standard that's consistent with your gender identity or your gender expression. So if you're gender identifying as female and there are 2 uniforms, one for males, one for females, you wear the female uniform. You're adhering to the dress code standard and you're able to use the one that's consistent with your gender identity or expression. Okay. Thank you very much. I'm going to pass it over to Stacy.
Well, and thank you for that great overview. Okay, now we have kind of the big picture, what the protections are. But this is how my brain thinks. I need something concrete. What is real? How does this translate into a person's individual experience? And this is the reason I brought up the case scenario. Does everybody have a copy of the case scenario? Anybody missing? And I also need someone who likes to read. Is there anyone who is outgoing and likes to hear the voice?
I have my reading class.
Did I get everybody?
Yeah, I know.
Did you read it?
Do you need me to hold it for you?
Yeah, you focused perfectly.
I know.
All right, what? Should I
read
read?
the paragraph? Would you mind? This is a
Certainly.
case scenario to show people what this law really means in practice, okay? And this is a real case. Not in this jurisdiction, but in a jurisdiction very close to ours in 2007. So this all happened, okay?
So I'm starting with Crystal.
Yes, if you could, thank you.
Crystal is an employee for the State Transit Authority. She was born as a biological male and given the name Michael. She, however, identifies herself as a woman and has lived and dressed as a woman outside of work and used the name Crystal. She has begun taking female hormones to prepare for sex reassignment surgery in the future. While she has begun to transition from male to female by taking female hormones, she has not yet completed the sex reassignment surgery. She described herself as a pre-operative transgendered individual. Nearly 4 years after she had begun taking female hormones, she applied for a position as bus operator. She was hired and trained. Do I get to keep reading? Okay.
Oh, yeah, you're doing great.
Okay. During her training period, she presented herself as a man and used male restrooms. Soon thereafter, she explained to her supervisors that she was a transsexual and would dress as a woman. The human resources manager met with her and asked her where she was in the sex change process and whether she still had male genitalia. Crystal was forced to explain she still had male genitalia because she did not have the money to complete the sex change operation. The human resources manager expressed concern regarding Crystal's use of public restrooms along the route. Crystal used female restrooms in line with her gender identity. The nature of the transit routes Crystal worked required her to use public restrooms.
Great, very nice, thank you. So the first question I would have to ask you is, what do you think happened prior, say this is Nevada, prior to the enactment of the statutes we just heard about, what do you think the likely consequence for Crystal was? She get fired? Did anyone say anything about maybe the harassment she went through? No, right? And that is actually the reality. Prior to having gender identity and gender expression laws, this is exactly what happened in Utah. This case happened in 2007 in Utah. And what the court found there was that, and I'll read this, unless someone else wants to volunteer, but that the Transit Authority discharged Crystal based solely on her intent to use women's public restrooms while wearing a UTA uniform, the uniform of the Transit Authority, despite the fact that she had male genitalia. UTA states it was concerned the use of women's public restrooms by a biological male could result in liability for UTA. This court, and this is the 10th Circuit now, agrees with the district court that such a motivation constitutes a legitimate, non-discriminatory reason for, and Crystal's name was STC, termination. And they found that the Transit Authority's reason for termination was legitimate and non-discriminatory. And this case was brought under Title VII and Section 1983. So that's really troubling. That's a horrible result, right? I mean, and this is 2007. So the reason I put that on the table is I want us to think about, say this case were to happen in Nevada today. What do you think the likely consequence would be? What kind of opportunities would Crystal have to challenge what happened to her? Any thoughts?
Isn't Nevada a right to work state?
Well, that's part of the issue. Also part of the issue is, would this be considered discrimination in an employment context based on gender identity and expression? It would. And so she could file a complaint with NERC saying, I was discharged based on my gender identity. What else? What about the fact that she was asked specifically about the nature of her physiological change? What do you think of that? Inappropriate. Very inappropriate. And other jurisdictions that have looked at this issue, for example, the DC Office of Human Rights, In the District of Columbia, they've had gender identity and protections in place since 2006. So they've done this for a while, and some of the regulations they put together specifically describe situations like this. And I want to share that with you, just so you know, this is unlawful harassment. And it is inappropriate for any employer to ask questions such as, what is your individual body? What is the nature of your physical transition? Another area that is very important to recognize is on the use of pronouns. Say, for example, in this instance, Crystal came to her boss and said, I identify as female. I would prefer to be heard the term she and her. And the boss consistently said, I'm not going to say that. I'm going to call you he. I'm going to refer to you as male. That happens, right? I mean, it's a reality. That's also harassment. That's also inappropriate. The New York Commission on Human Rights, and they've had their law in place since 2002, has specifically said to avoid the appearance of discrimination, individuals should be addressed with names, titles, pronouns, and other terms appropriate to their gender identity. So the right thing to happen is for the company to say, how would you prefer to be addressed? And if the individual says she or he, those are the appropriate terms to use. It is inappropriate to say, are you pre-op, are you post-op? None of those things are of concern. They're very private, and they shouldn't be things on the table. So it's just important to recognize that there are protections now that used to not be in place. One of the other things that's really strange to me about this case is that it deals with public restrooms, right? This is an issue you raised earlier. How are restroom use to be determined? And as we've heard, it's based in other jurisdictions on your gender identity or expression. So essentially, if you have an internal sense of yourself as male or female, that is the restroom you are entitled to use. And that's true in a public setting, it's true in a public restroom, it's true in a restaurant, and you shouldn't be challenged. You should never have to provide ID that says, this is my gender identity. And you should, you raise the question of what if someone does? What if someone says to me, you're going to use the restroom as appropriate to your gender identity, and someone comes in is hateful and says, well, I don't believe you're X or Y gender. Show me your ID. That's harassment, and that's something that's actionable. You can complain to NERC, and also let us know at the ACLU. We want to know if people are being treated appropriately. We brought intakes, and we have our cards here. So if those things happen to you, we want to know, because it's important that the protections that are in place are adhered to, and that folks get their rights. And so that's important to know too, when you're looking at issues of public restrooms. Let's see. A number of states have looked at that issue: Colorado, Iowa, San Francisco, Washington, D.C., and they've all agreed that access is based on gender identity. And I think that's something helpful, and New York has said that it's discriminatory conduct to require to prove ID. And on public restrooms, as far as employers are concerned, some of the suggestions that are out there include, say you have an employer who has a single restroom, or maybe two, and one says men, one says female, that they should just put the word restroom on it, so it's gender neutral. And those are just kinds of accommodations people can make in order to protect people's rights and be respectful. I don't know if you have anything to add on the public restroom?
Just that the same thing extends in the workplace as far as restroom use. That if there are segregated restrooms, which there typically are, that whatever gender you identify with is the restroom that you're able to use. I didn't find any exception in the other jurisdictions about bathroom use, did you?
No.
No. So your gender identity is the restroom you are allowed by law to use in the workplace and in public places.
Right, and you can't be harassed for using that bathroom. That's important to know.